Supreme Court pushes for urgent rehab of homeless mentally ill in India. Supreme Court calls on government to seriously address rehabilitation of mentally ill homeless. New Delhi. In a powerful statement Friday, the Supreme Court urged the federal government to prioritize the rehabilitation of homeless individuals suffering from mental health conditions, calling it an extremely sensitive matter that demands immediate attention. This isn't just another policy issue. It's about our most vulnerable citizens being left without protection or dignity. The court emphasized during proceedings. The division bench of Justices Vikram Nath and Sandeep Mehta expressed concern after hearing that while discussions were underway, concrete action remained elusive. When government representatives requested an 8-week extension to report progress, stating, "We're actively engaged in deliberations and conducting meetings on this issue," the court responded firmly. This requires your utmost attention and must be completed with maximum urgency, the justices insisted, highlighting the critical nature of the situation. The case stems from a petition filed by advocate Gaurav Kumar Bansal, seeking directives for the development and implementation of comprehensive rehabilitation policies for homeless people with psychosocial disabilities, a term encompassing the social barriers and challenges faced by those with mental health conditions, often worsened by societal stigma and inadequate support systems. The court had previously issued notices to the central government and relevant authorities in April, requesting their response on this pressing matter. During Friday's proceedings, the petitioner pointed out that the government had yet to submit a detailed counter affidavit, though the bench acknowledged receiving a brief preliminary response. In a particularly moving moment, Bansal described the plight of homeless individuals with mental health challenges. They are literally being treated like footballs, kicked from one place to another, with no dignity or care. He emphasized that law enforcement agencies should be taking proactive steps to support rehabilitation efforts under existing legal frameworks. The advocate further highlighted that women constitute a significant portion of this vulnerable population, and noted that police often adopt a negative approach toward these individuals, largely due to the absence of proper rehabilitation protocols and guidelines. But here's where it gets controversial. Despite having progressive legislation like the Mental Health Care Act of 2017, implementation remains woefully inadequate. When Government Counsel referenced this law during proceedings, the court pointedly asked, "The legislation exists on paper, but where is the actual execution? Where is the compliance with these laws?" This disconnect between legislative intent and ground reality represents a systemic failure that continues to affect thousands of vulnerable citizens daily. The bench expressed its expectations clearly. "We anticipate a thorough and comprehensive response from the government addressing all these critical issues. Once they return with their plan, we will monitor implementation and work toward bringing this matter to a meaningful resolution." The petition specifically seeks directions for creating standard operating procedures, SOPs, for key stakeholders, including police departments and healthcare providers, to ensure humane and effective management of homeless persons with mental health conditions. The court has scheduled the next hearing for September 22nd, when the government is expected to present concrete steps taken toward addressing this humanitarian crisis. This case raises profound questions about our societal values and priorities. How do we balance urgent development with compassionate care for our most vulnerable? Should mental health care be considered a fundamental right? And what responsibility do local communities bear in supporting those who have fallen through the cracks of our social systems? Do you believe the government is doing enough to address this crisis? Or should more immediate and drastic measures be implemented? Share your thoughts in the comments below on how we might better protect those struggling with both homelessness and mental health challenges. Supreme Court urges Union to rehabilitate homeless mentally ill persons. The Supreme Court has raised a significant and sensitive concern, urging the Union government to promptly consider rehabilitation strategies for individuals who are homeless and mentally ill. This issue is not just a legal matter. It touches the very fabric of our society and the well-being of some of its most vulnerable members. During a recent hearing regarding a public interest litigation, PIL, that advocates for these rehabilitation measures, Justice Sandeep Mehta posed a critical question to the Union. Acts are there, but where is the execution? Where is the compliance? This pointed inquiry highlights a pressing issue. While laws may exist, their implementation often falls short. The bench, which included Justices Vikram Nath and Sandeep Mehta, pressed the Union of India for updates on the actions taken to address this dire situation. Additional Solicitor General Brigender Charhar responded by indicating that discussions are ongoing within the government, and he requested an extension of 8 weeks to provide a detailed progress report. Justice Nath emphasized the urgency of the matter, stating, "You need to take it very seriously and in as less time as possible." Advocate Gaurav Kumar Bansal, who initiated the PIL, passionately argued that homeless individuals with mental health issues are being treated like a football, kicked around without any real support or solutions. He acknowledged that his choice of words might be harsh, but he felt it necessary to convey the gravity of the situation. He pointed out that the law mandates police stations to assist in rehabilitation, yet there is often a lack of action, particularly when it comes to vulnerable groups, including women. The absence of adequate rehabilitation programs exacerbates the problem, leaving many without the help they desperately need. In response to these concerns, Justice Mehta assured that the bench is looking forward to a comprehensive response from a central government on all related issues, with the intention of closely monitoring the case. "We will try and take it to the logical conclusion," he promised, indicating a commitment to seeing this matter resolved. As the additional Solicitor General began to discuss the Central Health Authority's role under the 2017 Act, Justice Mehta interjected, reiterating his earlier point. "Acts are there, Mr. Charhar. Where is the execution? Where is the compliance?" This exchange underscores a critical gap between legislation and its practical application. The KIL not only involves the union government, but also includes various states and union territories, highlighting the widespread nature of the issue at hand. The next hearing is scheduled for September 22nd, and it remains to be seen how the government will respond to this urgent call for action. Case title, Gaurav Kumar Bansal versus Union of India and ORS, WP Open PL, number 198/2025. This situation raises important questions. How can we ensure that laws designed to protect the vulnerable are effectively implemented? What role should local authorities play in this process? We invite you to share your thoughts and opinions in the comments below. Do you agree with the court's assessment, or do you see the situation differently?